Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing the adjustment of status process in the specific context of a K-1 fiance who's entered the country for their 90 days of lawful status, presumably marrying their K-1 fiance counterpart, and they're seeking adjustment of status. As has been noted in previous videos on this channel, there's been a change in policy from USCIS. Specifically, there's been a memorandum that was issued over the summer coming into effect September 11, 2018, which effectively rescinded what was called the no possibility doctrine. Under the no possibility doctrine, an adjudicating officer for USCIS had to issue what's called a request for evidence unless there was, and I quote, no possibility that the case could be approved, notwithstanding an issuance of an RFE. That doctrine has been rescinded, and that is resulting in the possibility, and I would actually say the probability, that the officers adjudicating cases at USCIS can go ahead and deny a case out of hand without first issuing an RFE for clarification, which was done in the past and oftentimes resulted in a remedying of whatever evidentiary deficiency existed, thereby resulting in a probable approval in the case. Moving forward, that policy no longer exists. And so what we're seeing is what I think to be an increased likelihood of outright denial in certain kind of petitions associated with immigration benefits. This holds true for adjustment of status. Adjustment of status from a K-1 fiance visa over to an I-551 stamp, thereby issuing lawful permanent residence, aka a green card in the United States. This RFE policy applies to that protocol as well. So in the future, I think those who are filing for such benefits are well advised to heavily scrutinize their documentation before submitting such documentation to the USCIS due to the possible likelihood of denial based on lack of eligibility and denial out of hand without an RFE issuance, or where possible, consulting a legal professional in order to gain insight into what needs to be filed in order to have a successful outcome in a given case, and documentation that is inherent to the filing of an adjustment of status. Specifically in the memorandum which created this change in policy, they did note issues involving adjustments of status and so-called skeletal filings, or filings of simply an I-864 affidavit of support without the accompanying 485 form for adjustment. So it seems to me that they are sort of anticipating adjustment specifically, or they had it in mind at the time that this policy was changed. So the thing to take away from this video is we've had a sea change with respect to USCIS policy on adjudication of immigration benefits, and those who are seeking adjustment of status from a K-1 over to a green card are well advised to either highly scrutinize their petition for the adjustment or seek competent legal counsel in order to have assistance in order to best ensure a successful outcome in a given case.